stocks, securities, basically anything of value, including any artwork, coins, any collectible items that you may have, whether they have any financial value or not, that would still be considered part of your estate. Now, estate planning is a process of preparing for the transfer of your wealth and valuable items at your death. Estate planning is a very important step in your overall financial planning. Um, Essentially, that these documents that I'm going to be discussing is really going to be your last words on this planet Earth. So many people have many different reasons why they seek the services of an estate planning attorney. But some of the more common reasons why they want to set up these estate planning documents is because they want to decide and have instructions for who is to receive their estate at their death. They want to protect their family's inheritance from any divorce of family members or any estate taxes that may be due. And as important, they're looking to avoid any kind of family conflict. Just simply like to make difficult times easier. Estate planning is for everyone. It's not just for the wealthy. Whether you have a large or a small estate, everyone should have an estate plan. There are different kind of estate planning documents, and this slide you're looking at here are some very basic documents. The first one is your healthcare proxy. The healthcare proxy, allows you to appoint someone you trust to make healthcare decisions on your behalf if you should lose the ability to make these decisions yourself. So by appointing a healthcare agent, you can make sure that your healthcare providers follow your wishes. This includes doctors, hospitals, other healthcare providers. Again, that this document I'm sure everyone has seen at one point or another at hospitals. Usually they're given to family members. But the issue with these documents is that when you're presented with the healthcare proxy at the hospital, it will only be honored in that one institution, whereas the legal documents that we prepare, would be good in any medical facility in state or out of New York State. So that's the important difference. The living will, the next estate planning document, which is not to be confused with your last will and testament. The living will is basically your end of life wishes. It's a declaration that you do or do not want extraordinary measures undertaken to keep you alive. If you're permanently unconscious or in a comatose state, and a team of medical doctors decide that there's no reasonable expectation of your recovery from a terminal illness or an accident, you basically have instructions ahead of time that says, I don't want my life to be continued. I'm not looking to suffer, and I just want, my family to let me go, essentially. This document is essential, for one. Most folks don't know that hospitals actually benefit from keeping you alive because they get to, build a healthcare insurance as much as they can. So no one really knows if you're in a comatose state, you're in a coma, how much you're suffering. The other issue is if it really is your time, sometimes family members are not on the same page about whether to let you go, and this creates a lot of family conflict. Now, if you had a living will that has your wishes there stated in plain text, it would be much easier on the family to certainly make that decision for you, and everyone has to abide by it because it is a legal document. The next document is the appointment of agent to control disposition of your remains. I'm sorry, I skipped over the last will and testament. Let's go back. The last will and testament is a document, it's a legal document which comes into effect on your death. Okay, the last will and testament, basically you lay out all of the assets and the beneficiaries who are going to be receiving anything you leave behind in your last will and testament. You also appoint someone called an executor. Okay, the executor handles all of your affairs upon your death. They help, they collect any assets that are to be collected. They help pay any debts, file any tax returns, employ all kinds of professionals to help with the estate administration, and basically do everything that needs to be done to settle your estate. Now, again, it's not skipping the appointment of agent. So this is a document. Some people are adamant that they want their funeral arrangements to go a certain way, and they want a certain family member to be in charge when it comes to that, especially for people who want to be cremated and want other kind of services. Whether they want a viewing, a wake, or particular kind of music to be played during this service. You can certainly be as specific as you want to be in this document, and appoint who you want to be your agent or successor agent. Next is the power of attorney, which is a very important document to have during your lifetime. The power of attorney is where you basically select an agent, someone that you trust, and you give them the ability to represent your financial interests during your lifetime. And this includes a variety of matters. It's making gifts on your behalf. It's handling any banking transactions, selling any property on your behalf, retitling any assets, handling any tax issues or tax returns that you need to file. It's also helping with any litigation or continuing any lawsuits that you have going on. And I would say most important, they would be able to handle your Medicaid planning, which I will discuss shortly. Now, the power of attorney is a very powerful document. The one that we usually prepare is a durable power of attorney, which means that it will survive the moment of your incapacity, and it will also be effective upon you signing it. So that's the power of attorney. The statutory gifts rider is a supplement to the power of attorney. So this document, statutory gifts rider, gives your agent a specific power to make gifts on your behalf in excess of $500. Now, this ability to make these large gifts is important because if you become incapacitated and your current assets exceed the exempted amount, which would qualify you for government programs, or exceed the exempted amount, for tax purposes, it could be an issue if you don't have this document. So unless gifts or retitlement of certain property can be made, taxes will be paid or Medicaid will be able to claim against the excess property. And this might be confusing, but I'll talk about exactly what I mean when it comes to the long-term care portion of this webinar. The next document, I should say, is the trust. Now, trusts are basically agreements. They're like contracts. They can operate as last will and testament substitutes, which basically can be funded with any kind of assets, whether it's real estate or liquid assets. And there are two kinds of trust. There's revocable trust and irrevocable trust. So a revocable trust may be canceled by its creator at any given time, and this would require the trustee to return the property to the person who created the trust. The creator of the revocable trust has complete control over the assets during his or her lifetime. And in most cases, the person who created the trust acts as his or her own trustee. So assets, unfortunately, that are held in a revocable trust are considered completely available to creditors and the Medicaid program because the person who created it, of course, has so much control within the trust fund. So a revocable trust can be used by those who are interested in avoiding probate. It makes things much simpler. You don't have to go to court when you pass away, and title to any property that's held in trust can be transferred rather easily. It's also helpful to have a trust for people who have privacy concerns when it comes to administration of assets, because trust agreements are private documents, whereas your last will and testament, once admitted to the surrogate's court and to probate, becomes a public document which everyone will be able to see who you listed as beneficiaries. And if you actually listed any specific assets, they would have full, authority to be able to view everything you had in that document. Now, an irrevocable trust is treated as being permanent. So once property is placed into an irrevocable trust, it's deemed to be permanently owned by the trust. The good thing about the trust is that it does provide for both asset protection and asset management. And for those reasons, this kind of trust is often a large part of planning for long-term care. So these are your basic estate planning documents. And after you have now with some of these. The next issue that comes up in a conversation between us and our clients is whether there's any estate tax that will be due on my death. Well, we can't, tell what the future holds. The one thing we can say that the tax code will change. Anything related to taxes will always change. So, what we can say with certainty is if you were to die this year, the federal estate tax would consider everything you own at the time of your death. And the estate will basically include any assets, that pass with beneficiary designations or even assets that have joint owners. This will all be included for purposes of calculating your estate tax. So as I said, if you were to die in 2019, the amount of tax is determined by the application of the gift and estate tax exclusion, which is valued at $11.4 million. What this means is if you have less than $11.4 million of assets, you're not going to be charged with any estate tax. As far as I'm mentioning about the gift tax, it also depends on how much you gifted during your lifetime, because that would actually reduce your exclusion. So that's the federal estate tax. New York, like most other states, has their own estate tax program, except in New York, they have what they call a cliff tax. So what happens is if you have above $5.74 million of assets, they will calculate the estate tax on the total amount, whereas the federal government just calculates it based on anything that exceeds the figure. So in New York, if you have more than 5%, if you have 5% above the $5.74 million figure, essentially you fall off the cliff and the entire state would be charged with a state estate tax between 3% and 16%. So the other important thing to keep in mind is that New York has a 3-year look-back period from the date of death for gifts. What I mean by this kind of look-back period is if you made any large gifts within 3 years of your death, for estate tax purposes, these gifts will be brought back into your estate for the estate tax to be calculated. Now, again, even with all of that said, most folks, unless you have millions of dollars, for now, estate tax is really not a concern. Lifetime gifts and charitable gifts can actually reduce your taxable estate. So for 2019, the gift tax annual exclusion allows individuals to make gifts of $15,000 to any individual person, while married couples can make gifts of $30,000 to any individual person without having to file a gift tax return and without eating into their lifetime exclusion of $11.4 million. So for New York residents, there is an additional benefit of gifting the full federal exemption of the $11.4 million because such gifts will not be subject to any New York gift tax or estate tax. Making annual gifts is also something to consider and keep in mind when preparing for Medicaid eligibility, which, like I said, we'll discuss in a few minutes. So moving on to the next topic. So what is long-term care, right? So long-term care, well, there really is no fixed definition for long-term care. The need for it can arise as a result of any kind of disabling conditions or chronic illnesses. There are different kinds of long-term care services. Long-term care can be for people who need in-home care, or this is the type of care around the home with their basic daily living activities, such as feeding, bathing, cooking, and even help with medication, and so forth. In-home care affords the patient basically the ability to stay in the home and in their familiar surroundings where they're actually most comfortable. And although this tends to be the more convenient option by receiving care in the home, unfortunately, the home health aides or home health attendants can't always give you the level of care that you would receive in a nursing home. Now, the nursing home in the alternative is, of course, a much more inclusive program and can be for people who suffer from serious health issues that are, of course, too complicated to be tended to at their house or an assisted living facility. A long-term stay in a nursing home may be caused by Alzheimer's, Parkinson's disease, or even an injury due to a bad fall at the house. Nursing homes can provide a number of benefits, from in-home health aides, and nursing homes can also assist with daily activities, grooming, eating, bathing, all of the same things that I had mentioned about in-home care. Also lines of exercise facilities, just basically, everything to keep you going. These nursing homes can provide. There's also adult daycare centers, which are exactly what they sound like. They provide social activities for senior folks, meals and recreation, and mostly, sometimes it's a good option for families for children who do watch over their parents, but they have to work during the day. So sometimes it's an option to drop off the parent at one of these adult daycare centers. Next is respite care, which is short-term care for seniors, which basically gives a break to the caregiver family member to either go on vacation or run certain errands while their ill family member is cared for. Finally, hospice care. This is, end-of-life care and is really treatment for the terminally ill. This includes nursing care, doctor services, dietary counseling, just a long range of services, all kinds of physical therapy, occupational therapy, and is almost always, I should say, usually given within your home. Next question that comes up, aside from what kind of long-term care services there are, is what is the likelihood of needing long-term care? Well, many folks, seniors and young individuals alike, believe that they won't need long-term care, that their spouse or their children will take care of them. But with that said, despite this belief, there's many national studies that show otherwise. About 70% of individuals 65 or older will need some form of long-term care services, whether that's within their home or an assisted living facility or in a nursing home. This breakout also illustrates percentages of individuals needing long-term care for longer durations. Now, as to the cost of long-term care, which can really have some catastrophic consequences. So this slide was really meant to elicit laughter, but it's really far from funny if you're ever in this kind of situation where you need long-term care services, but you never purchase long-term care insurance. So now you're essentially forced to go through all of your life savings in order to pay for the cost of care. And being in this kind of business, helping families plan, seeing the Medicaid program, put liens against homes. I mean, these are pretty terrible things, because the one thing is for sure, we can never know, what our health is going to be tomorrow. People spend their whole lives, accumulating a certain level of wealth. They prepare for retirement, but no one ever really plans to get sick. And when that happens, there are some very unfortunate consequences. So regarding the cost, in 2019, basically, if you were paying out of pocket, you were privately paying. Typically, if you were looking for home health aides, 5 days a week, let's say 6 hours a day, you would probably be paying about $3,000 per month. If you were in an assisted living facility, there's a range depending on which facility. It could be $7,000 a month. Medicaid in New York State does not cover assisted living facilities. So Medicaid only covers home care or nursing home care. Now, if you're paying for nursing home care out of pocket and you stay there a couple of months or even a year, I mean, we're talking about $100,000, hundreds of thousands of dollars. I mean, you have to think about anything that you saved will literally go out the window before you qualify for any Medicaid or public assistance. So really, there's 5 funding sources for long-term care. As I said, you always have the option to private pay if you can afford it. And in fact, the state wants you to afford it, and they force you to afford it. The Medicaid program isn't free. It's really meant to impoverish you and to make you spend down all of your assets. But the key is to look for other sources other than private pay to fund your long-term care. But as I mentioned, long-term care insurance is great. If you have it, The daily benefit of these policies and the length of coverage can vary. It could be 3 years, 5 years. It could be up to $200, up to $500 per day. So it really depends on the policy, and it's a good product to have, but the issue is most seniors that we run into don't have it, and oftentimes when people are interested, it's already too late because they're too old, and these products are way too expensive. The Veterans Administration. If you're a veteran, there are certain benefits that you may be entitled to. For veterans with a 70% or greater service-connected disability rating, the Department of Veterans Affairs can pay up to 100% of cost of a skilled nursing care facility if it's a veterans care facility. So that's maybe an option, if you were an honorably discharged veteran. The next funding source is Medicare, which is not to be confused with Medicaid. So Medicare is a federally funded health insurance program that financially aids people who are 65 years or older and are seeking medical care. In many situations, people might think that Medicare will be your safety net. The program, as far as long-term care is concerned, in a nursing home, only pays for a short-term stay for 3 months or less, depending on if you're still benefiting from the rehab. So Medicare, again, is not really a way out. The best funding source is Medicaid. But the issue is, of course, whether you're going to be financially eligible to receive it. So Medicaid is a joint federal and state program. Medicaid is the biggest, definitely the biggest funding source of long-term care, and it does pay for over half of the long-term care in this country. The Medicaid program provides medical insurance for persons with low income and low resources, as I had mentioned. It's also available to provide for payments for the cost of in-home care. It is a means-tested program, and you have to qualify. Planning for Medicaid coverage is the best alternative. And, it's the best alternative because it has the least economic impact on your finances. And it essentially allows for you to leave all of your assets to family. So what is the financial eligibility? Well, on the income end, income eligibility rules for home care. So we're talking about in-home care. We're not talking about nursing home care right now. So for in-home care, for a single individual could keep up to $859 of income per month. Okay, all income over $859 must be used to pay for the cost of home care services. Now, a married couple who are both receiving Medicaid can be paying up to $1,267 of income per month, which again, this is nothing. Usually, folks' Social Security checks alone are above these amounts, which easily, disqualifies you unless you set up a pooled income trust to take in that excess income and essentially make you Medicaid qualified. I won't get into pooled income trust. That is outside the scope of this webinar, but just something to keep in mind. There's very serious income limits as well as resource limits. So resources, we're talking about assets. So assets that are non-exempt. So this is assets that are considered available to pay for your cost of care. The individual Medicaid applicant, okay, who's 65 years or older, can keep up to $15,450 in 2019. These numbers change every year. Now, the allowance for a married couple who are both looking to receive Medicaid, that figure is $22,800. There are certain assets that are completely exempt. So for home care purposes, if you live within your home and you're receiving the care, the primary residence is exempt. Any burial accounts or prepaid funeral expense arrangements that you have, any tangible property is also considered exempt, as well as any life insurance, so long as the base amount of the policy is less than $1,500. If it's more than that, then any cash value of the policy is considered available to pay for your cost of care. Now, the great news is in New York State, Medicaid to pay for in-home care, there's no look-back period. So, and that's not the case in other states, okay? But in the state of New York, if you were looking to qualify for Medicaid to pay for the cost of in-home care, we can easily transfer any excess assets you have out of your name, and the following month submit the Medicaid application. Now, in states like New Jersey, unfortunately, if you wanted in-home care in New Jersey, there is a 5-year look-back period. So your choices are definitely more limited in other states. So now this is, we're going to talk about the financial eligibility for the nursing home. So the nursing home allows you, the Medicaid recipient who is institutionalized, they allow you to keep $50 a month of your income, which is absolutely nothing. I mean, these days, that's not even enough for a haircut. Anything above $50 is going to pay for the cost of the nursing home. Now, the spouse, there's a healthy spouse that's living at home. The spouse can keep an allowance of $3,160.50. This is for 2019. Now, if the spouse has less than $3,100 per month of income, we can shift over some of the institutionalized spouse's income to the healthy spouse to bring him or her up to this level, so that this way we can protect more of the income. But if the healthy spouse was already receiving more than $3,160, at that point, the Medicaid program would require that the healthy spouse contribute 25% any of his or her income that exceeds this $3,000 figure. So again, just like for home care, you're allowed the same. They give you the same allowance of $15,450. So you're allowed to keep this amount in your name and apply for Medicaid. This is the institutionalized spouse. Now, the healthy spouse who's living at home, if we're talking about if this is a married couple situation, the healthy spouse can keep a minimum of $74,820 or one half of the couple's total assets up to $126,000. So anything that would exceed that, you would have to pay for the cost of the nursing home care. Of course, here there's also certain assets are exempt. So the primary residence, if the non-applicant spouse is residing there, is exempt. If there's any burial accounts or funeral expense arrangements, that's also exempt. And tangible personal property, the same typical rules as we had discussed for the home care. So all of that would remain, of course, exempt. Now the house, even if there was no healthy spouse, let's say, the house can still remain exempt if the institutionalized spouse was going to be returning to his or her home within 6 months of checking into a nursing home, or if this house was occupied by a minor, blind, or disabled child, or even an adult child. So the house would be exempt. So, I mean, there's some ways that you can kind of protect your assets depending on what your life circumstances are. But in some situations, you have to absolutely, plan for your long-term care. So the 5-year look-back period, of course, applies. When you put in the Medicaid application, they look back 5 years. And what I mean by that, any bank account you have, any financial account, anything finance related, they want to see statements. They want to see bank statements. They want to see financial statements going 5 years back. And they will literally, the Department of Social Services will go through every transaction with a fine-tooth comb looking to see if you've made any gifts. And I'll talk more about what happens once they find these gifts. Usually there are penalties. But let's move on to the next slide before we get into that. So again, these are your countable assets. When you apply for Medicaid, you have to disclose everything you and your spouse have in your names: cash, bank accounts, mutual funds, or any real estate, life insurance. You have to show them everything, okay? And that's how they decide whether you qualify or not. They literally look at everything under the sun to make that decision. So there, sometimes we get clients in and they assume that any of the joint accounts they have with their children, that they're protected somehow from Medicaid, and that the Medicaid program wouldn't touch them because, it's really my child's money. Well, that could be the case, but unfortunately, for bank accounts or any kind of joint accounts like this, the Medicaid program presumes that you are the 100% owner. So that becomes a real problem. So now of course, their presumption can be rebutted. If you can submit evidence that it was really your child that was making deposits to this account, then that's one thing. If you can't, then they're going to consider 100% value of that asset to be yours. Um, so the next item that comes up in Medicaid planning is a spousal refusal. So if the community spouse, I mean the healthy spouse, so if the healthy spouse owns assets in excess of that resource allowance, let's say above that $126,000 figure, the healthy spouse can refuse to make their excess resources available to pay for the medical expenses of the spouse that's being institutionalized in the nursing facility. So the Medicaid eligibility will not be denied to the spouse that's in a nursing home because of such refusal, but the Department of Social Services will initiate a court action against the healthy spouse later on in order to recoup any payments that were made in the medical facility. But the Department of Social Services recovery for payment of the cost of medical care can take place when the recipient of benefits dies or even during the recipient's lifetime. So I always tell clients that this option should be used only as an absolute last resort because essentially a spousal refusal, the spouse has a legal obligation to support their spouse. By doing a spousal refusal, you're allowing the Department of Social Services to step into your shoes to come after the sick spouse for any Medicaid benefits that were paid forward. If there's any after acquired assets, so I'm talking about post Medicaid eligibility. So after the initial determination of eligibility, you're qualified for Medicaid. Any assets that the healthy spouse receives are exempt. So they're not going to look at these assets. Any assets acquired by the institutionalized spouse that's in the nursing home are not exempt. They are definitely going to look at these assets and consider them available to pay for the cost of care. So again, the concern is always what am I going to lose? What happens if I don't qualify for Medicaid? What happens if I have too many assets? And what's really with this look back period? So just to pick up where we left off regarding Medicaid penalties, if you apply for Medicaid, any gifts or transfers of assets that you've made within the past 5 years, that's 60 months, any transfers that you made within 5 years of the application are subject to penalties. And by penalties, I mean a period of ineligibility. So the transfers that are exempt from these Medicaid penalties are if you've made any gifts to a spouse. So any interspousal transfers are exempt from Medicaid penalties. Any gifts that you've made to a minor child are exempt. Any gifts that you made to a blind child of your own, of course, it can't be someone else's children, are exempt regardless of their age. If you had a disabled child, like I said, I mean, the issue with that is you can transfer your assets to a disabled child, and that could help you protect these assets from your Medicaid eligibility. But if your child's an SSI, that could be a separate issue and interrupt their public benefits. So that is just something to think about. You can also protect the family residence by transferring it to a minor child. You could protect the family residence by transferring it to a sibling. So by transfer, I mean retitling the property, doing a new deed and having a new deed recorded in a county clerk's office so that the property is not owned by the person who's receiving Medicaid. So if the transfer was made to a sibling of the Medicaid applicant, you can protect the property as long as that sibling lived in a house for at least 1 year prior to the Medicaid eligibility, and also that sibling had some kind of equity interest in the property. There's also an exception if there was an adult caretaker child. So there was a child that lived with you within your residence for at least 2 years, and has really helped take care of you and has prevented you from going into a nursing home sooner. You can transfer the house to the caretaker child penalty free. So how are these penalty periods calculated? Well, usually what they do is, as I said, they look 5 years back and they calculate, they tabulate altogether any gifts you've made, and they divide this amount by what they call a Medicaid divisor. Okay, this divisor for this year is $12,419. So just by way of example, if, let's say, in the past 5 years, you're going into a nursing home today, and in the past 5 years, you have made $100,000 worth of transfers, gifts, to children, nieces, nephews, uh, you know, other people, neighbors even. If you've made gifts to people and these gifts were not the exempt gifts that I had discussed, they're going to basically tell you that you could have had this $100,000 today to pay for your cost of care. So what they're going to do is they're going to penalize you for it. And how they do it is they take that $100,000 figure and they divide it by $12,419. So this essentially gives you an 8-month penalty. What that means is you have to pay for the first 8 months of care at the nursing home before any Medicaid benefits will kick in. So unfortunately, that's how that works. And it's really unavoidable. Unless these gifts were made in limited amounts. If they find anything above $1,500, withdrawals, transfers to foreign accounts, they're going to calculate all of that and pretty much use it against you. The other weapon they have against the Medicaid applicant, as well as the family, is the estate recovery. So federal law requires that states attempt to recover benefits, any benefits paid for medical assistance from the recipient's probate assets. So what I mean is if the individual dies and if there's any assets that were left solely in his name alone without any beneficiary designations or joint owners, the New York State can essentially try to recoup from these assets for any Medicaid benefits that were paid. So, if a spousal refusal was asserted, they can come after non-probate assets even. So even if everything of the individual was passed, all of these assets went by rights of survivorship, at that point the state can come after those assets. So I mean, this is why I say that spousal refusal is really, it's only appropriate if the healthy spouse really needed the additional assets to live because there just wasn't enough income. So an alternative to all of this is really asset protection and having some sort of gifting strategy in place that won't disqualify you from Medicaid eligibility. So as far as gifting is concerned, basically anything that's a gift is in the Medicaid program's eyes is considered the equivalent of an uncompensated transfer. So you didn't receive value for it, therefore we're going to penalize you for it. So if you made a transfer, for less than whatever its fair market value was during the 5-year look-back period, that the presumption will be that you've done it for purposes of establishing Medicaid eligibility, and that's how they hit you with a penalty. However, if these gifts were made, on birthdays, holidays, Christmas, Hanukkah, other holidays, it could be acceptable to the Medicaid program provided that these gifts were reasonable and there was a continuation of this gifting pattern, which began, say, years before the person developed this medical condition that landed them in the medical institution. As far as the family home and what's the best way of protecting it and why I really want to hone in on this is because for most folks, their real estate is their biggest asset. Probably for senior folks, the mortgages is paid off. They're very proud of this home. Maybe it was in a family for multiple generations, and that's all they can think about. And they're worried about losing their house if they do become sick, because the Medicaid program does put liens against the house. They can't kick people out of the house, but if the house is ever to be sold, they are going to come and try to collect against, the sale proceeds of their house. So I want to go over first the wrong solution of protecting the family home, in the anticipation of possibly needing Medicaid within the next 5 years or so. So by transferring it to your children directly, which is an option, there are certainly certain risk factors that come with that, but this is pretty much problematic, because the child can have creditors of their own that can sue the child and place a lien against the house. If your child winds up in a bad divorce or something like that, that property can easily be subject to a distribution to the child's divorcing spouse. Also, if your child is receiving any public benefits, such as SSI, that transfer might cause them to lose their benefits, if this child doesn't occupy the place as their primary residence. There's also a lot of tax disadvantages with transferring your family home directly to your children. And what I mean by that, I'm talking about capital gains, folks. So, for example, if the parent, let's say, paid $100,000 for the house that's now worth $400,000, the $100,000 that they paid for it is the cost basis that would carry over to the child. What this means is that when the child turns around to sell the house, there will be a capital gains tax on the $300,000 profit. So assuming a combined federal and state capital gains rate of, say, 25%, the tax would be $75,000 or more. So this is definitely a serious tax. This is seriously a serious tax disadvantage. I don't know how to turn that off. Thank you. 1 second. Let me just, sorry about that, folks. Okay, the other disadvantage is losing the exclusion from capital gains tax that typically, if the place qualifies as your primary residence, individuals, if they had occupied this place as a primary residence for 2 of 5 years preceding the sale, you would be allowed for an exclusion of $250,000 from any capital gains tax, or an exclusion of $500,000 from capital gains tax. So if you make an outright transfer to your children, you will unfortunately lose this exclusion from capital gains tax if the home is later sold. Another disadvantage, tax disadvantage of transferring the home directly to your children is losing the step-up in cost basis. The step-up in cost basis, the cost basis is what you paid for the property. So the step-up means that on your date of death, if you still own the property, the new cost basis would be the fair market value of the property on your date of death. So if a parent, say, held onto the property until death and then left the property to a child, the child receives a step up in the cost basis to the fair market value on date of death. But just by way of example, if the home is worth $600,000 on the parent's date of death, the child's cost basis would now steps up to $600,000. So if the child sold the house right away, there would be no capital gains tax. Now, if the child waited to sell the house, there are still benefits later. So if you made an outright transfer during your lifetime for any of your children, you will lose the step up in cost basis when the home is later sold. You will also lose any exemptions, that you have from property tax, such as Star, Enhanced Star, seniors, veterans exemptions. You will certainly lose those if you transfer the property outright to your children. So what's the right solution here, folks? Well, the right solution is setting up what's called an irrevocable trust, which easily eliminates any of these risk factors that I have discussed, and has all of these tax advantages. So let's just go back to some of these risk factors. So if the child is sued by a creditor, right? If there's any judgment against that child, that will not affect the house that's funding the trust, because the child, he's only a beneficiary of the trust fund. He doesn't own the house, so his creditors can't touch it. If the child becomes divorced or any divorce settlement or judgment, there'll be no impact on these assets because, again, they're held in trust. The assets are not in the name of that child. And of course, if the child is receiving any public benefits, if these assets are held in your separate trust, this doesn't affect, his SSI or that child's Medicaid in any way. Um, the most important thing is if the transfer to an irrevocable trust was made outside of the 5-year look back period. So if you make a transfer today and you didn't need to go on Medicaid for the nursing home within the next 5 years, 5 years pass, the house is off the table. Medicaid can't touch it. Officially, it is protected from the Medicaid program as long as 5 years pass from the date of transfer. The other benefit is, even though the house is held in trust, you get to keep your exclusion from capital gains tax. The house can still be sold, even though it's held in trust. The house can be sold and you could downsize. The trust can purchase a smaller place or a bigger place. I mean, the bottom line is having your residence held in trust doesn't change your lifestyle in any way. Of course, the trustee of the trust cannot be you or your spouse. It would have to be your child or someone else because you don't want the Medicaid program to take the position that you have too much control over the asset because then they can challenge the trust. So if the trust was to sell the property and purchase a new one, it would not restart the look back period. The look back period only goes from the first transfer, which is another benefit. You would also, if you were to pass away, if the property was held in trust, you would receive a step up in a cost basis, and again would minimize any capital gains tax if after your death, your children or family were to turn around and sell the house. And finally, even though the house is held in trust, if you are receiving Star Enhanced, Star Veteran, Seniors exemptions, you can still have those exemptions reinstated as if you still own that residence. So basically, everything in a nutshell. Estate planning and long-term care planning is extremely important, because for one, it provides maximum security for the non-Medicaid spouse, the healthy spouse. It avoids the tremendous burden on children and other family members, and it essentially preserves your legacy, everything that you worked so hard for and wanted to go to your children. It helps avoid any Medicaid liens or anything that would reduce, what your children are rightfully entitled to. So that, I mean, to conclude this, proactive planning for long-term care is the best way to go. It will protect, anything that you have in your name from the government, and it's not illegal. It's legal. It's planning. It's having the right documents in place. It's doing everything important so that when you're no longer here, your children can have the life that they deserve, the life you wanted them to have, essentially. And I'll see if there's any questions. If there's no questions, you can always email me any questions. You can call us. As I said, we have 2 different locations. This is our phone number. My email's there. Our website's there. Our initial consultations are free. If you want to come in and discuss your estate, if you need for us to, if you had documents already done, I'm happy to look at those to see if there's anything missing or anything else that maybe we can do for you. And other than that, that's all I have for you folks.
Thank you again, Carl. So let's see if anybody has any questions for you. If you have any question, we can add them to the Q&A box. You will read them and try to answer all the most we can. But if you have individual question and you want to speak directly to the lawyer, you can definitely reach out to him. His information is right on the screen. Also, the webinar it has been recorded and it's going to be posted on our website. So if you want to view it, if you missed something, you can come back and listen to it again and take some notes. It will be posted in a few days.